right, friends. Shalom. Wonderful to be with you all again for another webinar in the series that Chidush is offering together with Ruach Chidush, Rabbis and Kenters for Religious Freedom and Equality. And we have the former chair, Professor Rabbi Michael Chernik, and board member, I see Rabbi Neil Gold, possibly others. At this point, I can't see all the pictures and all the names, with J-Plan, the Jewish Pluralism Legal Action Network. Hi, Neil. Jewish Pluralism Legal Action Network, and one of the people who apologized in advance because of conflict is J-Plan's co-chair, Judge Peter Buxbaum, and others may be on the maybe on the call, and our wonderful partners, the American Association of Jewish Lawyers and Jurists, and its president, Steve Greenwald. This time, we are exploring, we are alternating between topics of Jewish rabbinic interest and topic of legal interest involving Israel, and some, like today's topic, that are of interest to both groups and touch on both issues. So Israel is a Jewish and democratic state, and the particular challenging issue of what is the role of Jewish law, of halacha, of mishpat ivri in a Jewish and democratic state. And we are delighted to have Dr. Benny Porat, Vice Dean of the Hebrew University Law School and a director of the Institute for Research in Jewish Law, present the issue to us. Dr. Porat has been teaching in numerous universities around the world, and he is the editor of the Hebrew edition of Shnaton HaMishpat HaIvri and co-editor of the English edition of the annual Jewish Law report. And his most recent book is about justice for the poor, the principles of welfare regulations from biblical law to rabbinic literature in Hebrew. So we know it's not too late for those who do not have good command of Hebrew to start having it. Hopefully the pandemic will finish before you feel fully at ease with the fine points of Hebrew, but it's a worthwhile challenge. And the justice for the poor and its Jewish law context is certainly a worthwhile topic to be explored. One more point before I turn it over to Dr. Porat, and that is that our next webinar, responding to popular demand and requests that we have received, will be on December 28th, 3 weeks from now, back to Monday. And the speaker will be Professor Ruth Halperin Kedari, who is the founder and director of the Rachman Institute at Bar-Ilan University Law School. And she will be speaking about freedom of marriage, civil marriage in Israel. Why is it so important? What is this really about? Who is affected? How are they affected? What should be done? And we'll have a little bit also of what is it to you, namely, what can American Jewish community, Jewish leadership from around the world actually try to do about it? So December 28th, the next webinar on freedom of marriage. And it's over to you, Dr. Porat. Bevakasha.
Thank you very much, and I'm very pleased to be here, and I want to thank Uri, if I may, for inviting me to be here. And I've been asked to speak about the project of Jewish law, Mishpat Ivri, and I will say a bit more about the terminology. The terminology here is very important, about the project of, I would say, reviving Jewish law within Israeli law as a Jewish and democratic state. So I would like to share with you some slides, and we can read some materials together and then discuss them. So I would like to start my talk with some preliminary assumptions, because a lot talks about Jewish law and Israeli law, and there are a lot of stereotypes and a lot of assumptions which are not always true and correct. And as you can all assume, this is a very hot topic in Israeli law, or maybe we can mute others. And this is a very hot topic also within Israeli politics and within Israeli legal system. And if you are following what happened in Israel in the last years, so you can see a kind of a reviving of talking about Jewish law in Israel. And I think this is a good point to discuss thoroughly the nature of this project, its advantages, disadvantages, the differences between reality and the vision. So I would like to give some thoughts about that. I think maybe Ori, we should mute everyone, and then I will unmute myself.
Yes, I'll mute everybody again.
Yeah. Okay. So when we speak about Jewish law, so of course one should distinguish between Jewish law and Israeli law. Yes. So we're speaking here about two separate legal systems. When we speak about Jewish law, we mean the national legal system of the Jewish people, the national religious legal system of the Jewish people. Whereas when we speak about Israeli law, we speak about the prevailing secular legal system of the state of Israel. So there are two separate and distinct legal systems. And of course, that's the relationship between the two. This is one of the challenges of Israel as a Jewish and democratic state. So finding the right balance, or to say the place for Jewish law in Israeli law, I think this is one of the deep fundamental challenges of Israeli society, especially from the standing point of defining Israel as a Jewish and democratic state. Now, what is very important here to note, it's about terminology in what we mean when we say Jewish law, because there is some difference here between English and Hebrew, and the difference is very significant. When we speak about Jewish law, and mainly about the Hebraic terminology of Mishpat Ivri, as opposed to Halacha, we spoke about Jewish law, Mishpat Ivri, Halacha. So we're making these distinctions. And when we speak about Mishpat Ivri, we speak not about the entire Halachic world, but we speak about the legal parts, the legal aspect of Jewish law tradition. If I had to translate Mishpat Ivri into English, I think the translation would not be Jewish law, but it will be something that more like Hebraic jurisprudence. And jurisprudence, which is to say, we speak here only about legal issues like torts, contracts, administrative law, constitutional law, and so on. We are not speaking here about the laws of Shabbat, or the laws of kosher food, or the laws of Passover, or things like that. We speak about pure legal materials, and it's not Jewish, it's Hebraic, because what we have to remember, that part of the idea of Mishpat Ivri project, it's a secular project, and it's very important to mention and to put some emphasis on this statement. This is a secular project of coming to the world of Halacha and trying to derive from the Halacha some interesting legal insights that can enrich and inspire our legal world from a legal cultural perspective. So this is not a religious project. This is something that's much more secular, cultural project. And therefore, there is a very clear and sharp distinction between the project of Mishpat Ivri and, for example, what happens in the area of marriage and divorce and conversion. So we will speak more about marriage and divorce, I assume, in 3 weeks from today. But the Mishpat Ivri project is not about marriage and divorce and conversion. In marriage and divorce and conversion, from variety of reasons, Israel decided to apply the halachic system on these areas, and you can all assume how sensitive and complicated this decision is, and what are the prices that Israel pays for this decision. Also, there are some advantages, but this is an halachic project of taking the halakha as a religious system and apply it on Israeli society with regard to marriage, divorce, and conversion. And here are all the sensitive questions of religious coercion and freedom of religion, freedom from religion, and so on and so forth. But this is not the project of Mishpat Ivri. This is not the project of Jewish law. The project of Jewish law is coming to the Jewish legal library and trying to focus on legal issues and derive some interesting insights in order there to be a source for inspiration for a modern secular legal system. And I will, in a minute, I'll give a few examples. I would even dare to say that the most important leaders of this movement, of the Mishpat Ivri movement, from the first half of the 20th century, where most of them were secular, and their most important opponents were the rabbis. Because the rabbis were against the idea that there will be secular interpreters of the halakha that will try to take some parts of the legal parts of the halakha and interpret them and take what fits to the Israeli legal system. And at the first half of the 20th century, there is a lot of contradiction between the Mishpat Ivri movement and the rabbinical world. From some mysterious reasons, and maybe we should open this for discussion later, at some point of the history of Israel, the Mishpat Ivri movement is moving from the secular parts to the religious part, and then it's identified with some religious aspirations of applying halakha on Israel legal system. But we have to remember that at least the basic nature of this project, it's about coming from a cultural perspective to review the halachic world and finding some sources for inspiration. And in order to give you some sense of what it's all about, and I'll try not to give you a boring lecture of law professors, but to bring some interesting issues. So I will give a few examples of the footprints of Jewish law within Israel legal systems that we're taking on this platform from the Hallachic library, and were reinterpreted in Israeli context and gave a new modern shape. So of course, I will skip on this slide because I'm not sure that we have enough time, but I would say it like this. From the very beginning of the Israel legal system, going back to 1948 and actually going back to the 30s and to the 20s, there were two competing visions about what should be the nature of the Israel legal system. So one vision were supporting the idea that Israel should develop a legal system that should be inspired primarily by Jewish law heritage and interpret this heritage in a modern fashion and take some elements that might fit and might enrich a modern legal system. So this is one vision of the Mishpat Ivri vision. And of course, that's the competing visions, the opponents held that Israel should develop an independent, eclectic legal system that should take the best of all worlds, from English law, from American law, of course from Germany, from French, and also with some insight from Jewish law. But Jewish law should not benefit from any priority with regard to other legal systems around the world. And I would say that the history of Israeli law is a tension between these two visions. So at the first years of the state of Israel, the first vision was more dominant, and you will not be surprised that going After that, to the 70s, to the 80s, to the 90s, the second vision became more dominant. This is the years of Ron Barak and other justices as well. And also, you won't be surprised that in the last, I would say, 10, 15 years, the first vision of reviving Jewish law as a main source for inspiration for Jewish law is now getting new voices in the Supreme Court of Israel, in the Israeli parliament, and in the Knesset. And now the battle came back, and there is a struggle between these two visions. Now, in order to give some flesh and what we are talking about, so I would like to share with you some examples about what is the meaning of modern interpretation of Jewish law as a source for inspiration for Israeli law. So here are a few examples. So of course, the most, I would say the most famous example is the idea of the duty to rescue. The question here is the question whether there is or isn't a duty on a stranger to rescue someone whose life is in danger, whether there is or isn't a law of the Good Samaritan law, what the Christian calls the Good Samaritan law. By the way, we have to remember that in many countries, of course, mainly in the US, there is no idea of duty to rescue. There is no duty to rescue. There is some Good Samaritan law in some of the US states, but not as a duty to rescue, but something that relates to compensation in torts, which is something else. Israel has decided in 1998 to adopt the Jewish law idea that there is a duty to rescue. Based on the famous verse in Leviticus, here you can find it in the words of Maimonides from the 12th century. Whenever a person can save another person's life, but he fails to do so, he transgresses the negative commandments, as Leviticus states, do not stand idly by while your brother's blood is at stake. Similarly, this commandment applies when a person sees a colleague drowning at sea or being attacked by robbers or a wild animal, and he can't save him himself or can hire others to save him. So according to Jewish law, there is a positive duty, affirmative duty to rescue. You won't find it in many modern countries. And at this stage, Israel decided at 1998 to adopt this idea and to enact the Israeli law, which is called "Lo ta'amod al dam re'echa," which is a quote from Leviticus, and here you can find the modern interpretation or the modern formulation of this Jewish law idea. And according to Israeli law, a person is obliged to prefer assistance when able to do so without endangering himself or his fellow to a person who, in close proximity and following a sudden event, is subject to a serious and immediate danger to his life, his person, or his health. And you can see here is the footprints of Jewish law in Israel law. By the way, I won't develop this idea here, maybe in the Q&As, but Israeli law didn't make a full copy and paste into Israeli law, but there are some slight differences between the original law in Jewish law and the Israeli law. There are some slight differences which are very interesting, and maybe we should discuss them later. But you can see here how Israel decided that as a Jewish state, it should get inspiration from such a law from Leviticus. Another interesting classic example, and later on I will come also to some modern example from recent years, the idea of unjust enrichment. A famous case that all of the modern legal systems are struggling with is about the following scenario. Let's assume, this is a case from American law. It's called Edwards versus Lee from Kentucky of the 40s. There are two neighbors. One day, one of the neighbors, Mr. Edwards, finds a cave in his land, and he's developing and cultivating the cave and make it to be a tourist attraction. He may make a lot of money. And after a few years, his neighbor, Mr. Lee, finds out that 30% of the cave is in his field, under his field, in his land. And therefore, he's suing Mr. Edwards for getting 30% of the revenues. So Mr. Lee says, you are benefiting from my land, you have to pay for that. Mr. Edwards argue, yes, but you suffer no loss because you have no access to this cave. I'm the only one who have access to this cave. So therefore, I admit that I'm doing some benefit from your property, but you suffered no loss. And here's a question. When one derived benefit from another property without causing any loss to the owner, whether or not he should be pay some, share with him his revenues or indemnify the owner. According to American law, according to English law, it's all about profits. It's about benefit. If you are benefiting from someone's property, you have to pay for that, whether or not the owner suffered no loss. And therefore, the American court says to Mr. Edwards, you have to pay 30% of the revenues to Mr. Lee because you benefited from his property, regardless of the question that he suffered no loss. This is not the Jewish law attitude. And according to Jewish law, it's not about benefit, it's about loss. And if the loss is zero, therefore the one who derived benefit from his neighbor property does not have to pay for that. And let's read first, here you have the Maimonides idea. And the law is called זה נהנה וזה לא חסר פטור. If one derived benefit and the other suffered no loss, then you are exempt from paying, from indemnifying him. And the idea is that be more patient. You don't have to sue the other person every time that he uses your property. If you suffered no loss, so nothing happened, it's not a big deal. And the quote of Maimonides here, it's when a person dwells in a courtyard belonging to a colleague without notifying him, if the courtyard is not usually rented out, he's not required to pay him rent. This applies even if the person who dwells within generally rents a dwelling, for one person is benefiting and the other is not suffering a loss. So this is a very Jewish idea regarding property, that if someone derived benefit from your property and he suffered no loss, so no big deal, and this is not a cause to sue him. Israeli law, as an Israeli lawmaker at 1979, decided to abandon the English attitude and to adopt the Jewish approach. And the law that called unjust enrichment law from 1979 reads as follows. When a person obtains any benefit from another person without legal cause, the court may exempt the beneficiary from the duty to make restitution if it finds that the receipt of the benefit didn't involve any loss to the benefactor. And intentionally, what the Israeli lawmaker is doing here is adopting the Jewish idea, giving it here again a slight interpretation. This is not exactly the Jewish law approach, but it is very similar to the Jewish law approach. And according to Israeli law, contra Anglo-American perspective, if there is no loss, so there is no cause for paying, for making restitution if someone derived benefit from another person. I will give a few more examples, and some examples also are going back to modern times. Of course, one famous example is regarding euthanasia. It's a very famous case and a very famous law from the, I would say, 15 years ago. And Israel was struggling about the question about the laws regarding euthanasia, and following a very tragic case that was brought to the Supreme Court of Israel. They were giving a Supreme Court decision, and then the Knesset also enacted a law which adopted the Hallachic, the Jewish legal tradition distinction between passive and active euthanasia. And in Israel, active euthanasia is prohibited, passive euthanasia is permitted. And there is a kind of a balance between on the one hand, the idea of sanctity of life and the idea that we will not take part in speeding the death of someone is ill and want to bring his life to death on the one hand. On the other hand, we want to ease the suffer of a terminally ill patient, and the halachic balance that was adopted in Israel was making a distinction between passive euthanasia, which is permitted, and active euthanasia, which is prohibited. And this is also a very interesting decision of Israel, that regarding to bringing the human life to death, it should be on the balances that Jewish law developed during its hundreds and thousands of years. There are also some very interesting examples from the Israeli Supreme Court. Jewish law plays an interesting role not only in the Knesset, in the Israeli parliament, but also in the Supreme Court of Israel. And I would like to bring some interesting Supreme Court decisions where Israel, the Israeli Supreme Court make interesting use with regard to Jewish law. I will skip on this slide, and I would like to focus on the following one, which is, I think it's more interesting. Take, for example, the case of marital rape, an interesting case from Jerusalem of 1980, where a husband raped his wife. There were no dispute about the facts, but the husband claimed that according to English law, and I'm not speaking here about 1480, but about 1980, only 40 years ago, according to English law, which was a prevailing law also in Israel, in Israeli criminal law, marital rape is not considered a rape. And because she is his wife, and if she's wife, so a person cannot rape to be considered as a rapist of his wife. And this was a case that brought before the district court in Jerusalem and then to the Supreme Court. And of course, the Supreme Court of Israel felt very uncomfortable, to say the least, with this decision that marital rape is not considered a criminal offense, and they looked for an alternative way to look on the issue. And in a very interesting way, this is called the Cohen versus the State of Israel case. And in a very interesting way, the Supreme Court decided, at least one of the justices, not all of the justices, but one of the justices, decided to base his decision on Jewish law. According to Jewish law, the husband is not allowed to rape his wife. His wife is considered as a separate legal personality, and the husband and the wife are considered from Jewish law perspective as a two different and distinct legal personalities, and therefore, according to Jewish law, the wife can sue her husband for torts and in criminal issues and so on and so forth. And here, what is very interesting is that the Supreme Court of Israel decided to adopt the Jewish law interpretation of the relationship between a husband and a wife contra the Christian medieval interpretation. So what is the story here? Why, according to English law, a rape of a wife by her husband is not considered as an offense? So the reason is going back to medieval times, where in some Christian sources, the interpretation of the famous verse in Genesis, yes, that therefore a man shall leave his father and mother and be joined to his wife, and they shall become one flesh. So the Christian medieval interpretation of the idea of being one flesh is that the husband and the wife are becoming one entity, a legal entity. And if they are becoming to be one legal entity, then a person cannot rape himself, and therefore a person cannot rape his wife, because it's like raping himself. Now, Jewish law rabbis rejected this interpretation. They thought the husband and the wife as two separate legal entities, and therefore they even suggest that wives will sue their husbands, and the Supreme Court of Israel decided in 1980 to adopt this Jewish idea of relationship between a husband and a wife, and therefore the husband was convicted, and after that also the law was changed, and today in Israel and also in other countries as well, of course, marital rape is considered a criminal felony, and considered a rape that a person can be convicted and go into jail. These are very classic examples from going back to the 70s, to the 80s, to the 90s. What happened in recent years? In recent years, we can see a very interesting cases in the Supreme Court of Israel, where Jewish law takes a very interesting role. And I would like to give one or two examples from very recent years about I think the productive role that the Jewish law takes in the discussions in the Supreme Court of Israel. So, for example, we have several cases from the last, I would say, 5 to 7 years, which common to all cases. It's a very interesting tension between the idea of freedom of expression on the one hand and the right to reputation on the other hand. And I would give 2 examples. And the Supreme Court need to make a decision what to prefer the idea of freedom of expression or to prefer the idea of the right to reputation. So, for example, one famous case from, I would say, 5 or 6 years ago, it's called the Ilana Dayan case. Ilana Dayan is a very interesting reporter, and she had a television program about a very tragic case where a Palestinian girl in Gaza Strip was killed by an IDF officer. And according to the television program, she was killed intentionally by this officer. And later on, they were revealed that the officer, I would say it like that, later on that revealed that the information that was given to the reporter was deceptive from several reasons. The officer acted according to the security protocols, it was okay. And the question was whether or not the reporter should pay damages following slandering the IDF officer. On the one hand, she damaged his reputation. She hurt his reputation because he acted properly, and therefore, according to the idea of slandering, she had to pay damages on the one hand. On the other hand, she is a journalist, and if we want to give positive incentive to journalists to investigate and publish their research and investigation, then we don't have to give her a chilling effect and to give her negative incentive, and therefore we don't have to impose on her paying damages to the officer. And what is very interesting in this Supreme Court decision, that you can see here in this case decision, the tension between the footprints of Jewish law and the footprints of the American values. So you won't be surprised that the Supreme Court justices, who are very influenced by American writing, are giving precedent to the idea of freedom of expression, freedom of press, and therefore they held that the journalist should not pay damages to the IDF officer. On the other hand, other justices who were influenced by Jewish law tradition, the idea of zchut l'shem tov, or the right to reputation, held that in this case, the right of the IDF officer should be prevalent, and therefore she had to pay damages, and journalists should be more careful about what they are publishing. At the bottom line, the decision was in favor of Ilana Dayan and against the IDF. But what is very interesting in this Supreme Court decision is that Jewish law brought a very interesting voice of protecting the right to reputation contra to protecting the idea of freedom of expression. And you can see here is a very interesting voices in the Supreme Court of Israel. Another interesting case, which is much less famous, I think it's 4 or 5 years ago, it's the case from Jerusalem. The case is about a romance novel. There were two couples, a professor, by the way, from the Hebrew University, who had an affair with a young lady from Jerusalem. At some point they broke, and then he published a romance novel describing most intimate details of his ex-girlfriend, but without mentioning his name, but publishing all of his her very intimate details. She argued that you have stopped publishing this romance novel because he hurting my reputation. He's undressed me in public without photos, but with words. And he argued, on the other hand, that freedom of expression and freedom of literature, and you will not censor my romance. And in this case, the Supreme Court of Israel deciding, based on Jewish law values, an idea of protecting the right to reputation and the right to privacy, is that the publishing house should shelve the novel and bar its publication. And this was the outcome. And based on Jewish ideas of privacy and intimacy and right to reputation, the Supreme Court, in a very unusual decision, decided not to publish this novel. There are other examples as well, but I think that we are running out of time. And Uri, how much time do we have for this part?
1 second.
Once.
I unmuted myself. Yes, you still have, I would say, about 10 minutes or so, and then we'll turn to questions and answers. And this is a good time to remind our participants that you can raise your questions, comments on the chat.
Yeah. So there are other examples as well, but we don't have time for other examples. So I want to say a few more words about last debates about this issue in Israel. So I'll skip on this very interesting example, and I would like to go to the very famous law from 1980, which is called the Foundations of Law. So everyone knows that in 1980, the Knesset, the Israeli parliament, decided to give an official place to Jewish law. And according to this enactment from 1980, where the Israeli court comes to a question where there is no legal solution within Israeli law, where the court, faced with a legal question requiring decision, finds no answer to it in statute law or case law or by analogy, where there is a legal lacuna, where you don't find an answer within Israeli legal system, it shall decide it in the light of the principles of freedom, justice, equity, and peace of Israel's heritage. This is the original formulation, Israel's heritage. And I think 2 or 3 years ago, the Knesset decided also to add the explicit words of Jewish law and Israel's heritage. So in principle, according to this law, where the Israeli courts, Israeli judges are coming to a new question where there is no answer within Israeli legal system, then they have to turn to Jewish law and derive a solution from Jewish law. Everyone feels that, and everyone knows that the wrong interpretation to this law might bring to the undesirable outcome that Jewish law will be the prevailing legal system in Israeli law. And indeed, very quite short after this law from 1980, we can find the very famous and interesting debate between the two leading justices in the Supreme Court, Menachem Elon on the one hand, and Aaron Barak, the president, on the other hand. And you can find the Barak Elon controversy. And their controversy look like a technical debate, but it's not a technical debate. It's a debate about the place of Jewish law in the state of Israel. Those their so-called technical debate, it's about what is the right interpretation of the words finds no answer to it. What is a case where there is no answer within Israeli law? According to Aaron Barak, the president, let's start with Aaron Barak. Maybe let's start with Elon. According to Elon, the right interpretation that finds no answer is where there is no efficient reference in the law. So if you have a legal question and there is no efficient reference in the law, in these cases, you have to turn to Jewish law and derive a solution or inspiration from Jewish law. And one can imagine that, of course, there are a lot of cases where there is no sufficient reference in Israeli law to new legal question. And in all these cases, according to Elon, one should turn to Jewish law and derive a solution from there. And of course, Aaron Barak very shortly said, no, 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 this is not our intention. We don't want to go so intensively to Jewish law. We don't want to bow to Jewish law and to be bound by Jewish law. And therefore, Aaron Barak turned to just the opposite direction and derived and suggested a very, I would say, extreme interpretation. And according to Barak, the president, the right interpretation of the words finds no answer to it, that where there is no any reference to this legal question. So if you have a legal question and there is no slight reference in Israeli law to this question, then and only then you have to turn to Jewish law. And of course, one can understand that the amount of cases, the number of cases of where there are legal questions where there is no reference at all in Israeli law, not in statute law, not in case law, and not by analogy, of course, the number of these cases is zero. And according to the interpretation of Aaron Barak, to the foundation of law 9080, the result, the outcome was that actually there is no realistic application to this law because there is no real question, new legal question where there is no reference in the law, neither in statute law, in case law, or analogy. And according to Barak at 9080, there is no room to Jewish law, meaning room, significant room to Jewish law within Israeli law. But this is not the last chapter of their debate. And 10 years after, at 1992, 12 years after, Israel decided to enact another interesting law, fundamental law. And this is the basic law that's called the Basic Law Human Dignity and Liberty from 1992. And in paragraph number 1 of this law, Israel is defined itself for the first time as a Jewish and democratic state. The purpose of this basic law is to protect human dignity and liberty in order to establish in a basic law the values of the state of Israel as a Jewish and democratic state. Now, right after 1992, there was again a debate between Elon and Barak, Menachem Elon and Aaron Barak. What is the legal interpretation of a state which defined itself as a Jewish and democratic state? What is the meaning of being a Jewish state? And at 1993, 1994, we can find that according to Menachem Elon, being a Jewish state, it's a state to take inspiration from Jewish law. And Aaron Barak rejected this idea and said, no, Jewish state, it's a Zionist state, it's a state of the Jews, but there is no room for taking inspiration from Jewish law. But very interestingly, a few years after, we can see a change in Aaron Barak attitude, and he formulated differently his interpretation to this formula as a Jewish and Israel as a Jewish and democratic state. And from then on, we can find in his books and his very article, and this is a quote from his famous book, Constitutional Interpretation, in Hebrew, of course. And here you can find that Aaron Barak in 1996 finds that the Jewish law, it's not so bad idea if it takes the right shape and the right formulation. And Aaron Barak writes in his book, a Jewish state is a state where Jewish law fulfills an important role and where marriage and divorce of Jews are decided based on the Halacha. A Jewish state is a state that the values of the Halacha are part of its basic values. And there is no much difference between the words of Aaron Barak and the words of Menachem Elon. What happened to Aaron Barak? This is the question. What happened to Aaron Barak from 1980 to 1996? And what is the difference? I don't think that Menachem Elon it's not something that was so appealing about Menachem Elon, but something happened. I would like, and I'm not the only one, to suggest the following explanation. And I think that the law from 1980 gave to Jewish law a too dominant role. And according to the law from 1980, in every case where there is a legal lacuna, the Israeli court is bound to go to Jewish law and derive the solution from there. And if the Israeli parliament give Jewish law so intensive a dominant role, then Barak said it's too much and we have to reject it. And we have to interpret the law in order to give it no application. And therefore, Barak rejected this dominant role that the parliament, the Knesset members tried to give to Jewish law. But what he realized after 1992, that here Jewish law is not voicing a monologue, but it's part of a dialogue. And the idea of Jewish and democratic states suggests the Jewish law is one voice among other voices, and Israel should find the balance between the Jewish tradition and the democratic tradition. And from this perspective, that Israel as a Israeli legal system, Israeli Supreme Court should find the right balance between Jewish tradition and modern, democratic, liberal tradition. This sounds, I think, to Barak, something that's more reasonable, more balanced, and something that's more attractive. And from then on, I think, where Jewish law was given a much modest role of something that should have dialogue with democracy, with liberalism, with humanism, then I think Aaron Barak finds it something that's more reasonable and something that he can have a very interesting dialogue. Sorry. I will conclude with the following perspective about what happened in recent years in Israel. So I would say like that, we, the supporters of the idea of the vision of Jewish law, are struggling with two fronts. One front is those who are rejecting the importance of Jewish legal tradition and trying to abandon it, to reject it, and to shape Israeli legal system with no connection to Jewish tradition. So this is one front that we're trying to struggle with and trying to convince people that Jewish law can take interesting role in enriching and giving inspiration for Israel to develop its own legal system with some dialogue and connection with Jewish legal tradition. This is on the one hand. But on the other hand, the other front that we're struggling with are the fundamentalists who are trying to argue that the Jewish law project should be an Hallachic project. And the Hallachic world as a whole, as a religious Hallachic system, should be applied in Israel. And I would say it in the words of one of the Knesset members, Smotrich, who suggested that our vision should be to restore ourselves to the kingdom of David and Solomon, and this is our vision. And this is the other front that we are trying to struggle with. because I think according to the vision of the Mishpat Ivri project, the project is not to take Israel back to the first temple or to the second temple, but to build, I would say in a metaphorical phrase, to build a third temple, which should be democratic, humanist, pluralist, liberal, and have some interesting and productive dialogue with Jewish law sources, but not something that take us back to Middle Ages or to antiquity, but something that can build an interesting, modern, pluralistic state who take in the right way an inspiration from its legal tradition. And this is the basic idea, how to find the right way to take inspiration from a Jewish legal tradition, from the Jewish legal library, in a way that can enrich Israel as a modern, democratic, liberal state. And this is the thing that we are trying to struggle with, and to find the ways that this, I think, fascinating Jewish treasures can enrich in Israel and take Israel forward and not backwards. So thank you very much. And I think we have time now for question and answers.
Thank you so much, Dr. Porat. I think that the many participants in this Zoom call will agree with me that we have been privileged to hear an exemplary presentation of the issue with an exemplary use of resource material that I think has helped all of us better understand at least what you are trying to share with us and of course the topic itself. So before we turn to the questions that were already raised in the chat, I want to raise a couple of questions with you, and then I'll while you answer, I'll check the questions and share them with everybody and present them to you. Clearly, the last point you made, namely that this isn't about creating a theocracy, Torah state, but rather about building a third temple which is balanced, which remains committed to democracy and civil liberties, etc. Well, the quote you used to illustrate the transformation of Barak is problematic. And unfortunately, I don't have the text before me, but you will, I think, know. Barak strongly opposes the notion of halacha dictating marriage law for Jews in Israel. He actually explicitly wrote that the fact that marriage laws in Israel are based on religious law, whether Jewish for Jews or non-Jewish for non-Jews, is a violation of civil liberties, human dignity, religious freedom, and equality. So he strongly opposes this notion. The problem is that really the whole text? I vaguely remember that it is not. Actually, if I remember correctly, and I apologize in advance if I'm wrong, he presented three possible views as to Jewish and democratic. One is represented by this paragraph. Another is represented by rejecting the notion of Jewish tradition altogether. And what he is advocating is a balancing act in which we derive, actually very close to what you're saying, derive from the Jewish tradition that which is in keeping with the general democratic principles. If I'm right, then I think it's problematic to use this quote as representative of transformation of Barak. And the second question is you alluded to it already from the beginning. How do you protect the society? How do you protect the Jewish community? How do you protect world Jewry that is looking up to Israel from the Smotriches of Israel? And actually, it's not only Smotrich, it was the late, blessed memory, Minister Yaakov Ne'eman, who spoke about applying Jewish law in Israel. And actually, in the translation you used of the foundations of law, you refer to Jewish law, whereas the Hebrew language is Hamishpat Ivri. And you took great pains to explain that Hamishpat Ivri is not Jewish law. So there are clearly those who will jump on this and say, well, this is about the Knesset embracing Jewish law. And now, as just a couple of weeks ago or a week ago, the judge or the registrar at the Haifa court applied the nation state law and ruled that, among other reasons, for that reason, we should legitimize an act on the Carmiel municipality side to basically make it difficult for Arabs to live in Carmiel by refusing to provide them with subsidy for transportation to an Arab school because Carmiel has no Arab school. So clearly one can take a law and apply it in a way that is very far from what you've been saying.
Yeah. So thank you very much, Uri. And I would like to give 3 answers. So the first, with regard to the question of Aaron Barak and quote, so I didn't read it recently, but I quite sure I think that this quote at least represent the models that Barak support, at least in this text. But leave aside Barak, and we can then after open the books. And of course, Barak wrote a lot of books and articles, to say the least, and he raised a lot of voices and approaches. But I think Barak is not the subject. But I completely agree with you that there is no easy and convenient solutions. Everything here is very sensitive. Everything here is very complicated. And every time that we open Jewish law books, then very problematic things are popping out. And the question what we are doing with that. So it's very nice, to bring the nice ideas from Jewish law about the fact that a husband and a wife are 2 separate entities, and a husband is not allowed to rape his wife, and he can be sued by his wife, etc. So it's a very nice idea, and we want to embrace it. But on the other hand, everyone knows that there are a lot of other ideas in Jewish law with regard to the hierarchy between husband and wife that we won't want to embrace, and we don't want to bring it to Israeli law, and it's very complicated. But we do. But according to my vision, we don't have the privilege to reject all of these treasures, all of this library, and we have no other choice but trying to read it very carefully, to take the things that we think that might fit with regard to a modern and democratic state, and to reject or is the ways that the late Amos Oz said, we have to leave aside in the storage room the things that we don't think that should be brought into the upper level, and to keep it in the basement and not to bring them to the upper level. Now, and this is a third thing, what can we do to keep this vision and project being kept from the kind of Smotrich and other guys who are bringing a kind of a fundamentalist approach? What I say to my students at the Hebrew Law School, you should take part of this project. You should not leave it to others. And if you won't take responsibility about the question, what should be the nature and the interpretation of a Jewish tradition in your life, then others will do it for you. And then you won't have any other option but to blame yourself. And if you won't take responsibility on the interpretations, a modern pluralistic interpretation of this tradition, then there will be no vacuum. Someone else will do it for you, and you won't have control of it. So I think my most important suggestion is that all parts of Israeli society should take part in this discussion, should jump into these sources, trying to read them, trying to interpret them, trying to make distinctions between what is fits to modern Israel and what should be rejected and to leave aside in ancient history. And I think this is the only way, is that all parts of Israeli society will take part in this discussion and raise their perspectives and voice their attitudes. So, and therefore, I think it should not be a project. It would be very tragic if the project of Jewish law will be a project of the Orthodox religious groups in Israel, which is the current state for now, we have to say. So I hope that it gives some answer.
Yeah. Thank you. You certainly will have many on this call who sympathize with that notion. I think I'm not sure whether you have fully answered the question that David Light, co-chair of the Jewish Pluralism Legal Action Network, posed, but if you want to make any additional comment, go ahead. He is writing that he's interested in your perspective on the relatively new basic law, Israel as a Jewish nation, the nation-state law. Does this represent a swing toward the Hallachic approach to law?
Yeah, so I think it's a very fair and interesting question, and I would like to say this following statement. I think that the new basic law of Israel as a national state, I think it's an important basic law, but it's a very dangerous law if the idea of equality will not be part of it. And from my perspective, I think, like others in Israel, that the idea of equality to every citizen should be part of this basic law, which is not this is not a situation now. And without the idea of equality, that basic law might be a horrible law. So I think it has a lot of potential, but the idea of equality for every individual citizen in Israel should be part of this basic law. And here I would like to address an interesting comment, because there are those who argue that equality is very important, but should not be part of this basic law of Israel as a nation state of Israel. Equality should be, according to this argument, should be part of other basic laws. For example, the basic law of human dignity and liberty. And I say no. I think that the idea of equality should be part of this basic law of Israel as a nation state of Israel, because of the following reason. Because we all know that there are a lot of Jewish interpretations to the question, what is a Jewish state? And there are, and we can't hide it, there are some racist interpretation and there are some liberal interpretations, and there is a debate. We think the supporters of Israel as a Jewish state, what is the meaning of being a Jewish state? And therefore, from my perspective, it is highly important, it's crucial that in the definition of Israel as a national state, there will be it should be mentioned that the idea of equality is part of the meaning of being a Jewish state. It's not the kind of other basic law of human dignity and liberty, which is also important. It should be part of the inner definition of what is the meaning of being a Jewish state. Being a Jewish state is a state that gives dignity and respect all its citizens and recognize the civil rights of all citizens. And therefore, from my perspective, it is highly important not only that equality will be part of the Israeli constitution, but be part of this specific basic law.
Thank you. And to sort of further strengthen the point that you just made, shortly after the nation-state law was passed by the Knesset, we at Chidush, as part of our ongoing surveys of public opinion, included a question as to the degree to which the adult Jewish population supports entering into the nation-state law actually two additional principles. One is equality, and the other is religious freedom. And a clear, unequivocal response was an overwhelming majority that said, yes, people support the nation-state law, which clearly could be controversial for many on this call and outside this call. But at the same time, the majority of Israeli Jews, not politicians, but the majority of Israeli Jews want to see that law sort of strengthened and improved by including the principle of both equality and religious freedom.
Yeah.
Ted Goldberg is asking, are there any overall standards of when to apply Jewish law to overrule statutory or case law?
So this is a very interesting question, and of course, it's from the perspective of the foundation of foundations of law perspective. So of course, there can't be a contradiction between Jewish law and Israeli law, because if there is contradiction, so of course Israeli law is prevailing. So of course, if there is a contradiction between Jewish law and Israeli law, so there is no contradiction, because from Israeli constitutional perspective, of course, Israeli law as a secular law, this is a prevailing law in Israel. From this law perspective, Jewish law can play a role only in cases where Israeli law said nothing and there is a legal lacuna. Now, of course, this is a kind of this is a nice way to put it, but of course there are a lot of conflicts, and of course there are a lot of conflicts, and you just mentioned the case from Carmiel from a week ago, and the other cases as well. But here, for example, I think I will bring another case, interesting case on our table, and I would like to suggest it as a kind of a solution. So I mean the famous case of Shakdiel case. I think Shakdiel case go back to the 80s or to the 90s. And the Shakdiel case were a case where in the municipality of Yerucham in South Israel, the municipality wanted to nominate a woman, Leah Shakdiel, to be part of the Moatza Datit, of the religious committee of the municipality. And the rabbis rejected it. Now here, I think, and then there was an Israeli Supreme Court decision, which was very interesting. Why it was so interesting? Not because the Supreme Court forced the municipality of Yerucham to nominate a woman. I think this is not so interesting. This is obvious. So obviously, of course, the Supreme Court cannot hold the idea that a woman will not be nominated to be a member at this committee. But what's, in my perspective, very interesting in this Supreme Court decision, it's the opinion of Justice Menachem Elon. And what Menachem Elon did in this Supreme Court decision is not only arguing that from Israeli perspective, a woman should be nominated, but according to Menachem Elon, the right interpretation at this time, which is to say at the 20th century, from modern Hallachic perspective, should be that women should be nominated to such a committee. And according to Menachem Elon, and Menachem Elon says, I want to argue with the rabbis with their terminology, and I would like to write a legal opinion that holds also from Hallachic perspective that women should be part of these committees that should be nominated. And I'm not sure that Elon convinced the rabbis. I'm sure not. But just a few weeks ago, it was published that I think 30 years after the Shakdiel case, today in most, I'm not sure in most, but in many cities in Israel, women are taking part in these religious committees, Moatzot Datiyot, in many cities in Israel. And you can see here that on bottom line, the law was changed and the practice was changed, which is more important. And today women are taking part in these committees. So this is a small victory, but I think it's an important victory. And what it signified is the fact that I think the law can make changes, and what is more important, it can be expressed in Hallachic terminology and in Hallachic terms. And I think that the interesting contribution of this decision is not only to change the practice in Israel, but also to change the Hallachic perspective itself. And I think today it's quite common that a woman can take part in these Moatzot Datiyot, in these religious committees. So I think it gives some perspective about the complicated tensions between Israeli law and Jewish law and what happened when there is a contradiction. And I think that sometimes Israeli law can not only overrule Jewish law, but can reinterpret Jewish law itself and contribute to its development.
Well, that obviously is fascinating, and maybe we should be expanding on that at another time. I'll just mention that it is Chidush that threatened going to court if women were not provided the equitable role in Israel's religious councils. And in response to Chidush's ongoing pressure, the Attorney General instructed the Minister of Religious Services to appoint at least 30% women to all of Israel's religious councils and apply affirmative action when appointing women to senior positions. But of course, the sort of added dimension, which we don't have time to go into, is the question of women participating in the committee that selects the chief rabbis. And the position of the candidate at the time that no self-respecting rabbi would put up his candidacy to become a chief rabbi if, God forbid, a woman were to serve as part of that committee. And lo and behold, the Supreme Court ruled that one cannot reject women just because they were women. And of course, the next steps were sort of instructive, but we won't talk about it now. Steve Greenwald, president of the American Association of Jewish Lawyers and Jurists, says that on several amicus briefs we filed in the US Supreme Court in death penalty cases, we argued from halacha to interpret the meaning of cruel and unusual punishment. Is that something you want to comment on?
So yeah, so this is very interesting. Yeah, this is a very interesting issue about death penalty, and this is also very interesting, something that happened in Israel, because as you all know, or if not, maybe we should mention it expressly. Jewish law, Jewish religious law, is one of the ancient legal system, and maybe the first ancient legal systems that stopped the idea of death penalty, and it goes back to the generation after the destruction of the Second Temple, where Rabbi Akiva and Rabbi Tofon says that we are against, actually, in bottom line, we are against the idea of death penalty, and we are muting the idea of a death penalty. And indeed, in early Israel, the voices that were against the idea of death penalty were the religious voices based on the tradition of the Halacha. And based on the tradition of the Hallachic traditions, the religious groups, parties in Israel rejected the idea of death penalty. Now, what is very interesting in recent Israel, that is in a very horrifying way, that there is a kind of a turn, kind of a swing, where now today the Israeli right wing are supporting the idea of restoring the death penalty to terrorists and so on and so forth. But if you look carefully from a Hallachic perspective, so there is no more horrifying ideas that can be supported. And it's so surprising to find that the supporters of the halacha are supporting also the idea of death penalty, when it's a kind of oxymoron, it's a kind of a self-contradiction. And you can find here is a very interesting role and contribution of Jewish law. And you can also see here how politics might damage the genuine and interesting voice of Jewish law, and politics and culture are in a kind of a self-contradiction, and therefore it's so important to look very carefully about the interesting and unique voices of Jewish legal tradition. Yes, so death penalty, it's a very interesting case with regard to the US and with regard to Israel as well.
Thank you. I think we are nearing the end, because we are losing people, some of whom are apologizing for having to leave us, and many are complimenting you, Dr. Porat, for a wonderful presentation. So I want to say to Rabbi Ira Yudovin, who sent me a personal note asking whether we could approach Aaron Barak and see if he would be willing to give us, speak in one of those webinars. I'll certainly reach out to him. We'll see if he agrees. And Rabbi Gil Nativ, who mentions another aspect that obviously among the examples you gave, you weren't able to get to, even if you were thinking of it, and that is a case that I argued before the Supreme Court, that of Susan Miller, who is a Jew case, in which at one point the Minister of the Interior, who more often than not belonged to Shas, the ultra-Orthodox Sephardic party, and had an idea of how to square the circle, will amend the population registry law, and when we register converts, we'll put in brackets a convert, so that everyone looking at that ID card or that registration will know that one has to look into the bona fide credentials as a Jewess or a Jew of that convert. And a long quoting from Jewish law in explaining why that approach was unacceptable, and referring to Onat Geirim, writes Rabbi Gil Nativ, namely, you should not be, and then how would you translate Onat Geirim? You not only shouldn't be cheating or shouldn't be deceiving, but you shouldn't be offending converts. And that is a biblical rabbinic concept that should stand against it.
I would say that when the rabbis are trying to give an ultimate and fundamental example of how you should not offend the other person, so the ultimate example is that when you see a convert, you should not tell him, we all remember where we are coming from. And this is the ultimate example of the Mishnah in Masechet Bava Metzia. And it's so, I don't know if it's ridiculous or tragic that religious parties are trying to mention and making that all we remember is the converts where they are coming from. Yeah, so it's so ridiculous. Yeah.
So I don't know, maybe you would want to present that aspect of Elon's writing, Elon of blessed memory. I don't know, but if not, we'll find some other way of presenting it. Elon gave a little known lecture demonstrating how sort of the interpretation of Jewish law has descended from the early times when the High Rabbinic Court, or the Court of the Rabbinic Court of Appeal, validated a wedding, even though the Eidei Kiddushin, the witnesses to the Kiddushin, at least one of them, testified and declared that he was not an observant Jew and desecrated the Sabbath. And nevertheless, the Rabbinic Court found a way of upholding and validating that marriage, whereas 20 years later, the Rabbinic Court of Appeal, the same institution, in a similar case, chose to invalidate the wedding because of the witness claiming that he was not observant. So Elon's exposition of this shift in the application of Jewish law within the life of the State of Israel, I think is certainly illuminating. So if that is something you dealt with and you want to, on another occasion, present, I think it will be of tremendous interest. And I think respect Justice Elon's blessed memory. Any last words that you want to share with us before we conclude?
Yeah, so I would just say that from my perspective, I think we in Israel, we have so many, urgent issues, and we have so many things to solve. And Jewish law looks at times of one of the things that are not so urgent. But I think if you look bottom to this issue, and we're looking to the long term and not to the short term, so this is one of the most fundamental issues of the nature of Israel, how to find the right and balanced way of giving a voice and a role to a Jewish tradition in shaping Israeli culture, which on the one hand would not be too less, and on the other hand will not be too much. And I think that this is one of the most important challenges of Israel. And as I said before, I think the only way to do it, if it's all parties in Israel will take part in this discussion. It should not be left to one party, to one group, to only Orthodox religious group, which of course is very important. I belong to the religious Orthodox group, but it should not be left to only one group, and it should be a kind of a dialogue between all groups, by the way, also with non-Jews in Israel as well, and all should take part in the right interpretation of the meaning of Jewish tradition to us as modern Israelis in Israel of the 21st century. And this is only an invitation for an ongoing debate and discussion about these important issues. So thank you very much, and enjoyed very much this discussion. I hope that you enjoyed it as well.
Well, on behalf of everyone on this call and those that were forced to leave us early and those who weren't able to be here but will listen to it, thank you, Dr. Porat, for a fascinating and important and really enlightening presentation of a key issue that should be confronting and challenging all of us when we embrace the notion of Israel as a Jewish and democratic state. A reminder, 3 weeks, December 28th will be with Professor Ruth Halperin Kadari of the Bar Ilan University Law School to discuss the need for freedom of marriage, civil marriage in Israel. What is this about? Who is impacted? Why is it so important? And what may you do about it? Thank you again, and shalom.